trends move away from, the familiarity of your neighborhood. So I think there's a lot of houses in Mississauga, Toronto area that people are living there because they don't want to move out of that familiarity. And it is a challenge. Case in point, my parents moved from New Brunswick up to Ontario. We have a place in Sauvage Beach, so they moved near there. They moved back because it was very difficult to make new friends. Everything, you think high school is the clique. Well, you know what? When you're in your 60s and 70s, it's very cliquey when you're in small towns. So the trends really are, people are just waiting. They're sitting and waiting because they don't really know what to do. They don't really know next steps. And my recommendation to people is always just figure out where you are here, today. Figure out where you want to go, and then figure out a plan to get there. And just because someone says you have to invest this part in stocks and this in bonds, if that doesn't make sense for you, then don't do it. Because sometimes you just need that comfort of knowing that even though now it's a better time for GICs, but before even at a 2% rate of return, you have to have that sleep at night factor. So you really have to do what's best for you. And another trend that I find is parents are looking to downsize to help their children buy a house, because our kids are they can't buy properties now, just with the way rates are and the way prices are. So it's a big challenge. So again, it's just as Scott said, it's writing down what your wants are, what your needs are, what your wishes are, and then figuring out what the next steps are and what strategies you can use to get there. Because there's always going to be challenges, but there's always solutions.
Okay, thank you, Heather. And so Timothy, kind of on the same vein of the question, is what have you noticed in kind of this over the last few years in estate planning and wills and power of attorneys? Kind of the legal aspect of all these elements.
Okay, so I'm actually going to borrow Heather a couple of things that you said about the legal terms. So for one thing, when we think about baby boomers or them around, we are looking at significant net worth. This is what I'm finding. And Canadians love real estate. So when I look at the financial picture of clients, what it generally is, it's about 80 or 90% real estate, and it might be 10 or 20% liquidity, if that. And the second thing I want to borrow here is the trend that baby boomers are helping their children buy homes. We're looking at a huge transition of wealth in this country with the baby boomer generation. And it's true that more and more my clients are saying to me, I helped my son or daughter buy a home because him or her partner just can't afford it. And what that also translates to is, how do I estate plan so that I'm treating all my children equally? And so you end up with this sum of money, this net worth, and you think, okay, how do I distribute it fairly? How do I do things like minimize taxes? So that's to say, how do I distribute it safely? Which in turn translates to will planning, right? Well-drafted will, and a will should mesh with one's financial plan. So you often have financial planner, lawyer, even accountant, even realtor, right? Planning together, everything should mesh. I can get into, in this segment, more on how the finances should match with will, or various things in the Q&A session. I could talk about that.
Yeah, I'm going to talk about it now, sure.
Okay. So, how many times have I seen it where a will, unfortunately, disagrees with one's financial portfolio? What I mean is this: let's say a client comes to me and says, "Okay, I have 4 kids, and each child is to get 25%." Or I help this child more than that one, so we're going to make an adjustment. But then it might be that there is an insurance policy or a registered investment that doesn't match what the will says. So, come the death of the person, there could be a debate where one child would say, well, of course I want that insurance policy. Of course, my dad intended that I have this money happens to be 3/4 of their net worth. Too bad for my siblings. So another sort of look at this idea of the will says we get equal shares. And then you're fighting, then you're retaining counsel, God forbid, in court. So I always say to people, if that is your intention, make sure when the time comes, there's no contradiction between your will and your portfolio. Right? So if you visit Heather and say, here's how the insurance policy should look, here's how the RRSP should look, here's what my will says. Of course, it's never simple in Canada. There's tax planning that help with that. You've got to watch for tax pitfalls. So for example, RRSP is not meant for one spouse. Unfortunately, this is where you are. You can collapse that RRSP into the other. You can kind of defer the taxation consequences for a while. And that concerns a lot of people because they say, well, you know, if we're both gone, okay, I guess we finally have to pay some tax. But, you know, how do I survive once my spouse passes? So I realize a lot of that tips of a lot of icebergs, but
Yeah, sure, yeah.
questions, we make questions.
Yeah.
Well, and interestingly enough, the 100,000 left in a will and 100,000 left in RSP is not equal 100,000.
Well said.
So to each end, if you left 100,000 of a non-registered account and 100,000 of an RSP to get 2 children, they will not get 100,000 in time because the non-registered account has to factor in all the estate tax and all the estate fees, whereas the RSP flows outside. So it's just understanding. You know, I think that's the key is understanding the options and kind of reverse engineering and looking at what. Because when I look at someone's overall plan, I look at their review their will. It's usually actually work in a state trust department in banks. And I say, tell me what you want your will to do. Tell me what you want it to do. And I'll look at it and I'll say, well, that's not what it says. so it's, but you know, it's in a collaboration. I think that's the key too is, you know, unfortunately, you know, I think this is great that SPROG has, you know, put a number of professionals together because, you know, for some reason in the industry, you know, there's the financial professionals here, there's the accountants here, there's the insurance people here, there's the lawyers here, and nobody really talks to each other. So I don't think there's really a platform for everyone unless you seek the person out. So whoever you're working with, they should want to talk to the other people, professionals that you're working with, and if they don't, that's a bit of a red flag.
It's true. It's true. Well said.
All right, so just on the rapid fire here again. So Heather, I got one for you. In what way is health care planning important in a retirement plan on a scale of 1 to 10?
10.
Yeah.
Yeah, unfortunately. So the issue with, you know, your retirement plan is, you know, if you're a couple, you're always thinking of it in terms of being together. But the challenge and the biggest danger is what happens if one of you ends up with some sort of cognitive impairment, like dementia, Alzheimer's, and what happens if one of you ends up with some sort of physical impairment? You know, case in point, my dad is healthy. He's 83. He's done, you know, 25 kilometers on a bike up until 2 years ago. He used to walk for 2 hours. I think the only storm that we had in the country, you know, this year, we went out to shovel. There was some ice under the shovel. He fell, broke his hip and his bone, hit his head, and now he's got some cognitive challenges. He's got some mobility challenges. So he's been 6 weeks in rehab, and the hospital's an hour away because it's in New Brunswick, small town. My mom, who's 80, has been driving daily to see him. So, you know, now there's stress on her, stress on how he's going to come home, what costs are there going to be. You know, they had to retrofit the tub and the shower, so that's a cost. You know, thank goodness they have one floor, but you know, it's all my mom now basically can't leave him alone. And she's very independent. So, you know, you're gonna have to have people, you know, come in and look after him, so there's care costs. So healthcare is a big challenge. And then the second part is if one of you has to go into some sort of long-term care facility. Well, then your incomes have to be split because you have to look at what amount of money has to go to care for the care costs, and then also keeping, if you're living in an apartment, if you're living in a house, the cost for that as well. So now you've got two lifestyles you have to support and have to plan for that. So healthcare definitely is something that you really have to be aware of the challenges, going forward. And not only for the, the financial, but, the legal as well, making sure if there's a cognitive change in someone, that's it. You can't change wills or power of attorney. So you better make sure that's done before there's some sort of challenge in that area. Sorry to be doing with that. But it's all fixable. There's always a way, you just have to make sure you have a plan in place.
Okay, Heather, another one for you is name a reason you may decide to defer CPP or OAS.
Yeah, and that's, something that's been in the news and the media, even by my government body, the Financial Planning Standards Council. They've done, if you look at the pure numbers, it actually makes sense to defer CPP and OAS because of the fact that it's a guaranteed source of income that is indexed to inflation. So, there's a lot of talk about that it's not enough to support people, but additionally, CPP or OAS is income-based, not asset-based. So you could actually structure it so that you have no other reportable income, but you've got lots of assets. So for example, that's one way to use a tax-free savings account. If you have everything sheltered in a tax-free savings account, you've got cash flow from that but not taxable, and then you'll lay security, you may actually get a top-up if you don't have a pension from the guaranteed income supplement. Now, the way, you obviously can defer CPP and OAS and get more money, but then people kind of say, well, why should I have to use my money first? Because that kind of leaves less for your estate if you plan on passing it on, because if you defer it, you need to get the resources from somewhere else. So it may open up, opportunities to work past 65 if that's something you're interested in. But again, it's really just knowing your numbers and understanding why you want to do it and what makes sense to you.
Okay, thank you, Heather. Timothy, I have a couple of questions for you, and they're kind of related. The first question is, what is a will? And the second question is, whether you can download your own templates for wills and POAs.
Wow, good questions. A will is effectively your instruction as to how you want your property distributed upon death. So there's a legal guidebook, legally enforceable guidebook full of what we call requests.
Can you speak up a bit?
Oh, certainly. Some would say I have a soft voice. So, a bequest is merely that. A bequest says gift this sum of money or this thing, this car, this boat, to this person. That's all it is. You can almost bequest anything to anyone. And I say almost because there are certain automatic rights on death that can apply and that can override a will. Actually, speaking of questions that maybe listeners will often ask, they will say to me, I don't know about my son or daughter-in-law. I don't know if they'll stay together. Will my son or daughter-in-law have a right to my estate? The answer is no. There is no automatic right in that regard. But if a person doesn't make adequate provision for their own spouse in a will, then the spouse may have an automatic right. So let's say, I sneakily visit a lawyer and say, well, I'm married, but here's what I want to do. My wife's not going. No, she's not. When I die, she has an automatic claim as a dependent of my estate. So that's what a will does. Subject to those parameters, a will is just your instruction book. So you're a estate trustee or executor, being a person or people who manage your estate, distribute your property, pay your debts, manage your taxes, visit your financial planner, your lawyer, etc. That person manages your life when you're not around anymore. So that's what a will does. It says this person manages it, and this person to distribute it in this way. Now, I mentioned family law, I mentioned parameters around spouses. Taxes, there's another major parameter. CRA gets paid first, almost no matter what you do. So they're like an automatic beneficiary. Now, the second question, can you write your own? Can you download a will? Can you search Google? Very, very dangerous to do that for two major reasons. One being, you don't know that what you're downloading really suits your interests. Right? You can download anything. It might say last will and testament. You might think, oh wow, that's written really well, that's really clear. It doesn't necessarily suit what it is you want to do. And in turn, as Heather alluded to, what we want to do ends up how you structure your life. Even though you may not know it, because there could be a tax code, there could be anything there. So you need that collaboration. The second major pitfall to a download is you could be downloading a template that doesn't even apply in Ontario. So we've got this neat that one of the features of law is jurisdiction. Right? What's true here is not true in California. Similarly, a California lawyer can advise you on what to do in Ontario in some regards. Some things are federal, some things are state, some things are provincial. So you could be downloading a template that doesn't even apply to your region, where you're doing the legal system in which you live. So really, really dangerous. As I say, Dr. Google doesn't have a law degree, and so better to read and download and rely on.
Just on that point, what do you think about these new institutions or companies that are coming out like Will Full that have the online will kits and things like that? And because they're being promoted everywhere, and people I think are even trusting them because they were on Dragon's Den. So like what is the danger of that? I have a lot of clients that ask, it's cheap, it's only $200, and I said, well, sometimes you get what you pay for. So
That's it. That's it. I think the risk with that is what kind of legal advice are you getting? What kind of communication is taking place? Right? That's really, really dangerous. If I relied only on text messages or email or an AI assistant at the bottom of the website, I'd be in deep trouble. It takes a really in-depth conversation with someone as to what wishes they've got, what they need to do. It's a context. I literally have to get into a person's life in order to extract the facts that I need to provide proper advice.
And it's jurisdictional too, because like I was saying, my parents are in Brunswick now, so they're Ontario parents running are valid anymore. Like scary enough, you cannot in New Brunswick, if someone has any question of capacity, the healthcare system will not get involved unless the spouse has a power of attorney. So,
They're important. And it's true what Heather said. I mean, once you lose mental capacity, it's too late. It's too late to sign a DOA. It's too late to sign a will. If there's no caregiver, the public guardian and trustee will take over. And that's not preferable. It's preferable to plan it and have someone you love and trust sitting there for you, making decisions. There's the two major sites. There's the POA for the property, which would allow the named attorney to manipulate making investments, as I said, cars, boats, former property. And then there's the POA for personal care. That's health decisions. That's for dealing with doctors and nurses if you're in a position where you can't. If you don't sign one, you'll lose capacity. Discretion, that doesn't exist anymore.
you have to be careful. I have clients where there's two children and they wanted to treat them equally for giving them ability to make decisions. So one's a power of attorney for property, one's a power of attorney for health. Well, the person who has a power of attorney for health or for property is making decisions on the assets. Turns out that they had a business that went bankrupt, and now they're looking at mom and dad's assets to supplement their life, and they're 50% beneficiaries. So the daughter, who's the power of attorney for health, is saying, well, mom and dad need this care in this facility, and he's saying, no, it's too much, too expensive, find some business. So what's right for them health-wise, so you have to be careful of who you're trusting, and sometimes it's difficult to have two people to make those decisions, but sometimes it protects you as well. And like I said, I used to work in the estate trust department, and what I find is potentially it's a real conflict of interest sometimes if you have the power of attorney who's also the beneficiary. Because are they then making decisions based on what's important for them or what's important for, you know, the parent or the person?
I think the sister needs a lawyer.
Yeah.
I get your parents.
So Timothy, a question that
You know,
I've come across many times in my career in real estate is people passing away without a will. And what happens?
Yeah, good question.
What happens in that situation? I know you kind of alluded to that a little bit.
Okay, we're gonna talk about medieval law.
Yeah,
But, no, it's, well, see, generally speaking, it's not necessarily a disaster. It's a bad thing, but not necessarily catastrophic. So how it works is this: in Ontario, we've got a will. We turn to a statute called the Succession Law Reform Act, and it actually sets out what happens to your estate in the absence of a will. The problem is, it may not be the distribution that you wanted, number one. It means that someone, anyone, has to step up to be your estate trustee. It may not be the person you wanted, it may not be a person who works well with your beneficiaries. And practically speaking, it's a longer process. Okay, if there's no will that your estate trustee takes to a bank or a financial planner or insurance broker, you don't get the cooperation that you typically get from banks if you walk in with a notarized copy of the will. So as I said, not necessarily catastrophic, but much, much more difficult. And I suppose the person has nothing, then it may not make a difference. But as soon as you get into any significant property, oh yeah, it's you know, the paving of that road gets really important. I'd say anyone with significant net worth or anyone who has children should immediately then think about wills and powers of attorney.
Okay, great. Thanks, Timothy. Is there any other questions before we move on? Brad?
I have, you stand for ridicule here. I have a will taped in my fridge because I haven't decided exactly how I want to split things up. So I discovered that at the very least, I have 2 nephews and niece share equally. So I guess the first question is that a stupid thing to do? Is that valid? It's a will, there it is. And the second question, unrelated, is my father passed away. He was unhealthy. He had weeks to live, and he dispersed everything while he's still alive, which I didn't know he could do. And we all got checks, and he died penniless. Was that the smartest thing to do? From our point of view, it certainly was.
Well, so in answer to your first question, don't worry about distribution. You can request anything to anyone you want. You know, and that gets into, you know, issues of, say, even estranged children. You know, I've had parents say, do I have to leave X dollars to my children? They say, no, you don't. Unless that child is a dependent of you, say a minor child or an adult child that looks after you who is severely economically dependent. As I said, beyond the parameters, you can do what you want, you can request anything. I'm looking after an estate right now in which there is a fund, a major fund, to keep a horse alive. So that horse is dead. There's another beneficiary who said, well, I don't want to do that because that reduces what I'm going to get. They said, tough luck, there's a fund for a horse in the will. I don't know what he would do. But I said, I know I'm bound by the will, and frankly, try to convince a judge that that horse should be hurt to death because you want more money. So you know, back to your point, yes, nieces, nephews, sure, if you want. On your second point, distributing money prior to death, yes, absolutely. I'd say though, and Heather, you jump in if you want to. I see you smiling already, but you've got to be careful of the consequences of doing that. You've got to be careful of the consequences of breaking investments and potential tax consequences. The other thing that people like to do is add people to real estate as joint tenants, thinking, okay, I can avoid a probate fee if I add somebody. You've got to be careful of capital needs problems. You do things like that. So I always say to people, sit down with a financial planner and number crunch the averages first. Okay, option A might be for this fee, option B might be for that. So we've got some latitude in this country to tax plan legitimately. So I always say to people, do it. Minimize your taxation. Don't do anything illegal, but plan So whether your dad did it correctly, I don't know, but the mere fact that he did is not necessarily bad.
So we did it with the
Evidence
others.
it wasn't.
The day, we didn't know what was gonna happen, we were just going to the hospital. And the banker was there, the doctor was there, and his, anyhow, he sort of covered all the bases. That we may dispute, and all the doctor said he's a sound mind, that's good. The banker said, yeah, there's money, the lawyer said it's all legal. And we're just handing checks. And yet we smile on his face there.
Yeah.
Got free
Yeah.
penniless.
Yeah.
The only thing I might be concerned about, and I actually don't know if there's precedence on that, is if he had RSP and he basically cashed it all in. And so there's two things you have to be aware of with money on your passing is probate fees, which are things that flow through the will. And then there's your last tax return is a tax. And some things flow outside of the estate and are taxable, some things flow inside the estate and are not taxable. So you just have to know what the numbers are. So my only concern is if the RSP was all cashed out and they only withhold maximum 30%, and there's tax owing, but everything's been distributed, CRA can come after you within a certain time period to say, you know what, you owe us that tax. Even though there's nothing in the estate, that would be my only concern.
That is a concern, yeah. So what happens is, I mean, we all have a year in which we die. Tax return associated with that is the year of that tax return. We have a nasty thing in Canada called deemed disposition rule, which is that when you die, the CRA pretends you just liquidated everything you own. So with family cottages, there's a big problem. Scott, I'm sure you've seen this.
Yeah.
There could be a massive capital gain over that cottage, no matter what happened to it, when it was transferred. And that has to be paid. And how many times have I seen it where the family can't keep the cottage?
Yeah.
Because they have to liquidate it to pay the tax owing on it.
I see it with our RSPs.
Yeah, that's right.
Like all of a sudden, like, there's this massive, bill for RSPs in that year.
It's a
Immediate.
So that's income for that year. That's scary, right?
If you have an RSP worth 500,000 when you're passing, and that you were talking about, the issue where, if there's a couple and one person passes away, then all of your RSP assets go to the other. Well, now you've got that big RSP, and, the banks tell you, defer to 71 because, that's, the age that you don't have to start taking it out. But what that does is it just builds it up, and if you have an RSP of 500,000 and you're passing to the second person, Revenue Canada is gonna get a check of over 200,000, if not. So, that's where planning comes in, because I'm not a believer, unless there's a reason and the numbers work, to defer, RSPs to 71. Now, there may be, because again, I talked about if you have no other income than CPP and OAS, you may get additional government benefits. So I've got some clients who that's the only income they have, and they're deferring their RSPs to 71, so then from 65 to 71, they're getting guaranteed income supplement, which is an additional government benefit. So again, it's all planning. But yeah, I mean, that would be my only concern. If there is a tax bill, Revenue Canada
They wouldn't keep after us for anything.
doesn't mean that they won't.
To us, it was wonderful.
Yeah, no,
There was no fuss,
100%.
no fuss.
I would say that's the best thing to do, because, it just avoids the hassle, it avoids probate, and, if you've got all the parties there. And the only other thing would be concern is if it wasn't distributed as per the will. So say there was an estranged child at the time of your dad wanting to do that, and they were left out, then they could, sue you for.
And that's why we had the lawyer there, because there was
Right.
there was a
Yeah.
little bit of something with
Yeah,
a member of the
yeah.
family who only got a small portion, not an equal share.
And
But everything, that's why they had the people there, so
Yeah.
what he's doing is valid.
You know what, though, unfortunately, you can cross all your T's, dot all your I's. It still doesn't mean someone can't come after you and sue you. Whether
Right.
they have a valid
Right.
reason, you still have to defend it, which costs money. So
Right.
unfortunately, that's, not as
We're
bad
holding
as
our
it
breath and
is.
waiting for it, but it never happened.
Yeah.
Yeah, that's a
think
good
that's
point.
really smart.
Unfortunately, the state court, as we call it, it's more and more common. I mean, I'm seeing a lot of siblings fighting for a lot of things. Who gets the gold-plated toothbrush?
Oh.
Anything. The thing is, nothing to fight over.
Yeah, yeah,
So that's unfortunate.
yeah.
All right, well, I think we're out of time for this session.
Do you have a question?
Yes, I just wanted to make a point of clarification. When you're talking about power of attorney, that only kicks in if the person themselves is deemed incompetent.
Not
No.
necessarily.
May not necessarily. It can be as of incapacity. Most of the time, no, most of the time it's right away. But here's the thing, a named attorney has a fiduciary duty to act in the best interests of the grantor, the person that signed the power of attorney. Right, so it doesn't mean I can, hold legal assets and go on vacation.
Right.
You mentioned that brother and sister. The brother saying that's too expensive for mom and dad. No, that's a flat no. That money is for mom and dad. Before it's for him. And if he's a beneficiary of their estate, yeah, he's got to be really careful of that conflict of interest. Right. So my first duty as a named attorney or an estate trustee or a lawyer or a financial planner is to the client, to the person who granted that power.
Yeah.
Right. It's not a nice thing to be a trustee or named attorney. It's all the obligatory stuff.
Yeah.
They used to say at law school, property's like a bundle of sticks. Well, there's good and there's bad. Okay, all the bad goes to the trustee on their shoulders. The good goes to the beneficiaries.
I find that surprising. I thought they tightened up on that because I know of two recent cases where the person who had power of attorney could not act because the person involved had not been certified as incompetent. Two cases recently.
Okay.
So it did used to, like, you can specify that if you want.
Yeah.
You can say power of attorney only in place of, if there's incapacitation. I know just because we went up to visit my parents when my dad fell, and I just thought, you know what, we need to get power of attorney. So we did the enduring power of attorney, which is immediate.